Welcome to the McNees Litigation Podcast Series. This podcast will address potential liabilities related to Pokémon Go by Dana Chilson, attorney at law. Ms. Chilson is the chair of the insurance group and a member of the litigation, eminent domain, and injunction groups at McNees.
As most of you know by now, Pokémon Go is an application that can be downloaded to your smartphone or other device, such as a tablet. The application is meant to encourage people to get up, get outdoors, get some exercise, and learn more about their community, but most importantly, to collect Pokémon. Once various Pokémon are captured, they can then be trained at gyms and put into competition with other individuals' Pokémons. The Pokémons can appear almost anywhere. They could be on a sidewalk, on a front porch, or even in your very own business's lobby. Of course, all this is happening in the digital world, but you can hardly go anywhere without bumping into someone who is Pokémon hunting. What kind of liability could a business face if an individual is injured while hunting for Pokémon? The answer to this question depends on how the individual is characterized under Pennsylvania law. Pennsylvania law generally recognizes three sets of individuals that may be on a property: trespassers, licensees, and business invitees. A trespasser would be someone who has no reason to be on the property. Generally, a property owner is not held liable for injuries that occur to a trespasser. Property owners should be aware, however, of the concept of an attractive nuisance, which is generally any condition on the property that may be hazardous, and that the owner knew or should have known would attract certain types of individuals. A good example of this is a swimming pool. A property owner should know that a swimming pool might attract children, and if the pool is not properly secured, such as with a fence, then the owner might be found liable for the injuries, even if the person is a trespasser. I am not aware of any current lawsuits involving Pokémon Go, so it remains to be seen whether having a Pokémon on your property will be considered an attractive nuisance. The second classification is a licensee, or someone on your property with your permission. For example, if you're having a party, your partygoers would be licensees. The third classification is a business invitee, or someone who has a legitimate business reason to be on the property. For example, if someone comes to McNees's office in search of legal services, they would be a business invitee. For the purpose of today's discussion, a licensee and a business invitee can be analyzed in the same manner. The Pokémon Go application provides various marketing opportunities to businesses, which allow a business to use the hit craze as a way to bring people through the door. For example, a business can utilize a lure, request to be a Pokémon stop or gym, or to become part of a Pokémon quest. If a business utilizes these mechanisms, then it is likely that any person on the property hunting Pokémon will be considered a business invitee. Because of that, it is much more likely that a business will be held liable for injuries to business invitees. A business cannot be held liable for everything that happens on its property, however. The key here is to make sure that dangerous or hazardous conditions are appropriately marked. For example, if the floor was recently mopped and is wet, or there's a loose step, make sure there is proper signage so the public is aware of the danger. While you're probably doing these things anyways, you should pay particular attention to potentially hazardous areas during the Pokémon Go craze. So what takeaways do we have? First, figure out whether you have a Pokémon on your property. You can do this by downloading the application and taking a look around. If you do not want to be a Pokémon Go stop, there is a form on the creator's website where you can request to be removed. Second, determine whether you're going to use the Pokémon Go craze for marketing efforts, understanding that if you create a lure or otherwise use the application for marketing, that a person who is hurt on your property will likely be considered a business invitee as opposed to a trespasser, and there is thus a greater likelihood that liability will be imposed if an injury occurs. Third, make sure that any dangerous or hazardous areas are very clearly marked. Lastly, if an injury occurs, make sure to notify your insurance carrier right away. Most commercial general liability insurance covers bodily injury and property damage that is caused by an occurrence that takes place in the coverage area. In this instance, the coverage area would be your business. An occurrence is generally defined as an accident, so someone injured while Pokémon hunting would likely fall under this category, and your insurance carrier would likely have to defend any lawsuit and perhaps even pay out any judgment against you. Insurance policies usually have very specific notification requirements, however, and coverage can be denied if the insurance carrier is not notified in a timely manner. Make sure to carefully review your policy so you understand the applicable timeframes. If you have any questions about your policy, you should contact your broker or your attorney. If you would like more information on how Pokémon Go can affect your business, please contact me using the information on the following screen. Thank you.